It's everybody. Okay, good, good. Well, welcome. Isn't 2020 a great year? I mean, we're just having a wonderful time, everybody, between COVID and derechos and everything. So we got an idea. Somebody said, here's what we're going to do. Next weekend, we're going to have Thanksgiving dinner. And then the weekend after that, we're going to have Christmas. And then we're going to declare this year over so that we don't have to deal with it anymore. How's that sound? That's maybe that'd work. I don't know. Anyway, and then somebody else said, "Hey, quit saying what else could happen. It couldn't get any worse, because it could." So anyway, don't do that. So we're not going to say that. So welcome everybody. This speech, the idea of it started actually before the recent storm or any recent development. Brian and I were talking about this. What was it, Brian? Several weeks ago, you called and said, "Hey, would you help me do a pamphlet or something for our membership because we're getting these over aggressive public adjusters and storm chasers and people don't know their rights, and maybe it'd be a good idea to hand something out to people." So that's in the works. We're going to work on that. Also, there'd been some updates and there's some recent Iowa cases and also some different legislation that had been passed. So we wanted to do a little update on that as it related to storm chasers, okay, and assignment of benefits. And then there were some recent Iowa Supreme Court cases that were very helpful to us. So we want to talk about those. And then derecho. Well, happening in Cedar Rapids is what's happening in a lot of Iowa, but I think Cedar Rapids got hit pretty hard, and we've got people from all over the country now descending on Cedar Rapids, storm chasers, PAs. I'm hearing all sorts of stories about people being promised all sorts of stuff, and one tree $25,000 quote, amounts, and that's what everybody pay, and the insurance will pay the whole thing. Okay, yeah, well, no, probably not. You better look at your policy. But anyway, so all of that is on top of what we already had, and what I am seeing now, and it's really taken a toll on people. I know some of your adjusters are calling me. I'm dealing on claims, and they're calling me and saying, I'm done. I can't deal with this bullying and name calling and calling me on my cell phone at night at home, and people screaming at me and telling me that I don't know what I'm doing, and I'm trying to do this right. It's taken a toll on your folks. I know it has, and it's getting worse. And now with all these crop, all of the crop stuff on top of everything else, and the outbuildings and the farms, we're going to have some people that are teetering. Farmers were already in trouble. So anyway, you put all that together, and it's a perfect storm, and so to speak, and it's getting worse. So I want to go back to the title of the talk, because it says the talk is Storm Chasers, Public Adjusters, and Post-Loss Assignment of Claims. Okay, and I wanted to explain that. Some people use a shorthand of assignment of benefits, or AOB. Okay, assignment of benefits can be accurate. It depends on what they're asking. That is, the storm chasers or the PAs are asking them to sign. Okay, but a lot of times it's not just an assignment of the benefits. In other words, put my name on the check. Make me a payee on the check. Here's an authorization to do that. That would be an assignment of benefits in the true sense. But what they're doing is, and what they were doing prior, was an assignment of the claim, the whole claim, not just the benefits. And so that means they actually own the claim, and they can do whatever they want with it. And that's a little different than assignment of benefit. Benefits would be, you decide what you're doing with the insured and then put me on the check. Claim is, I own the whole thing. Okay, so just so we're all on the same page, what was happening was that we had the storm chaser law and we had the public adjuster law, and those were the association was involved in doing those, and did a great job on that through the legislature, and that was to curb abuses that we were having with storm chasers, especially coming in, getting people to sign all sorts of stuff. Okay, so then storm chasers can't any longer, after that law, act as public adjusters. They can't negotiate. They can't, as the insured. Okay, everybody understands that, right? We had the storm chaser law, the PA law, and that works. Okay, well, so then the storm chaser said, what could we do to get around that? Well, so they thought, well, we'll do an assignment of claims. Well, we won't say we're negotiating for the insured. We'll say we now are the insured, because we have an assignment of the entire claim. That was their next move, and that created all sorts of abuses in Iowa and elsewhere. Okay, and so and I want to read you this. It's in the outline, but just so we understand the magnitude of this, and that it's not just us, it's all over the country. And it was the worst in Florida and Texas, where they had the hurricanes. But the Iowa Supreme Court in its recent decision said, look, folks, you need to understand what we're dealing with here. And they said, in Florida, abuse of assignment of benefits has fueled an insurance crisis. The state's legal environment has encouraged vendors and their attorneys to solicit unwarranted AOBs for tens of thousands of Floridians, conduct unnecessarily expensive work, then file tens of thousands of lawsuits against insurance companies when they deny or dispute the claims. This mini industry has cost consumers billions, with a B, billions of dollars, and they are forced to pay higher premiums to cover it. This abuse acts as a hidden tax on consumers, helping to increase an already high insurance premium situation in this country. That we're dealing with that very thing here, and it's getting worse and worse and worse. And so, what happened was the legislature said, and maybe some of you on this call were a part of this, so I'm not being critical of this new law, but it was passed prior to the Supreme Court cases, which helped us. Okay, so let's look at the new Iowa Supreme Court cases, and I'll just boil them down. They're in the outline that you got, but there are 3 of them, and they were decided in 2020, and they all say whether if you have a post-loss assignment of claims, they're calling assignment of benefits, but some of them were assignment of claims. And if you have that by a storm chaser, they're really acting as a public adjuster. They're going around the storm chaser law, they're going around the public adjuster law, and they can't do that. So they declared them void. They said those contracts are no good, and they fined them too, which was great. And they put a cease and desist order in place to keep them from doing it anymore. Now, this was our old friends, all 3 cases, the 33 carpenters. And I know I see your names here on the call. A number of you have called me over time and said, what are we going to do about 33 carpenters? I mean, they're just ridiculous. I mean, I've got many. And by the way, they're sort of a spinoff from some other folks whose name you'd probably mention if I said it. And that same address, same people, change the placard on the truck, and then they do it again, and that's another deal they do. But anyway, so 33 carpenters, they were very aggressive doing this. Now you can't do it anymore. So that's good. Well, unfortunately, the law then that was passed by the legislature in 19, this is before the cases, said, well, you can do post-loss assignments, but if you do, you have to do X, Y, and Z. There's what I go through. And the hoops are primary disclosures. You have to tell the homeowner that this is true, and that the insurance company hasn't agreed to it, and that they have 5 days to cancel, and there's got to be all this disclosure language, specific language in big type so you can read it. Well, guess how much good that's going to do, because they just tell the insured, oh, this is just boilerplate, just paperwork, just sign it. What does this mean? Oh, don't worry about it, I'll take care of it, I'm going to get you a lot of money. Okay, so and so they can now do that is storm chasers now. We're not even talking public adjusters yet, just storm chasers. They can do post-loss assignments again. Before they couldn't because the court said they couldn't. But now with the new law, they probably can because the legislature has changed it again. And again, I'm not being critical of the legislature. I'm saying that happened prior to these cases. They didn't know that was going to happen. Had the cases come first, they probably wouldn't have done that because they could have relied on those cases, and that would have knocked out the whole problem, But now it's kind of muddied. So the question is unclear as to if the court gets another case, are they going to allow this sort of behavior again? And I assume if the storm chaser follows the law and puts the right type in and all that they'll let them do it. So it's kind of opened that up again. That's an issue that was unanticipated and nobody's fault. It's just that's the way it's happening. Well, I see the problem right now as not even so much a storm chaser problem as a public adjuster problem. We are getting the more and more public adjusters that are coming to Iowa, and some of them aren't from Iowa. There's one outfit that's out of Florida that's picking up a bunch of Iowa claims, and they're hooked up with a law firm that's a national law firm that does nothing but property claims against insurance companies, and they in turn have a whole nest of appraisers all lined up, and then there's some new PAs in Iowa that are getting super aggressive. Some of you on this call have heard from them. I'm dealing with, I think 4 different mutuals have called with a new public adjuster firm, and I don't want to say the name because they'll sue all of us if I do. But they're bullying, name calling, harassing, hoping that somebody will just pay them they want. And let me give you an example. And I don't know if this mutual is on the call or not. I can only see some of the names, but $30,000 claim already paid a year ago. Okay, we finally got the estimate from this PA, $192,000, 40% O&P and supervisory, PPE because of COVID, on and on and on. I mean, it's just, and what they're doing is they're setting up their appraisal, or their lawsuit. So, that's the game. And we were having that game before, but we're having it again. And part of the game is they don't tell the insured what's going on, so I think that we're entering a phase here where storm chasers were backed off some by the storm chaser law. Then they were backed off again by the Supreme Court cases that say you can't do the assignments. Okay, and now they're going to pretty soon discover, aha, we got a new Iowa law, we can do the assignments again. They're going to redo their forms, and we're going to see them emerge. Okay, so you're going to see more storm chasers from all over. And then the PAs are getting more and more aggressive. And this game that they're playing, which those of you that have been through appraisals and lawsuits with these public adjusters are very familiar. You work up your claim in a real number and you get, and usually they're hail claims because there's so many, all at one time. They come in, they want to sign everybody up, and they go down the street and sign them up, or somebody says, hey, we have these people and they're going to get me more money. And have any of you been looking at, there's a new group in Cedar Rapids that's derecho restoration or derecho information, exchange or something. Anyway, it was designed because our internet was down. email was down, everything was down, and so but some people could use their phones and could use Facebook. So people were trying to get information out, and actually the city and the TV stations were using Facebook to get information out because there was no other way. Well, the PAs have discovered this group, and they put stuff on there like, "Are you having trouble with your insurance company? Call us. We won't charge you anything until the insurance company pays you." And then one of them has on their website, I heard yesterday, a video of a big insurance guy bullying an insured and telling them they weren't going to pay and they were being ridiculous and all that. And this goes on and on. Now, there's a new one in today. There's another one that I've never heard of from out of state. Same thing. You're being abused by your insurance company. Anyway, these are all public adjusters. Okay, so the problem, I would say, in the last several months has evolved into, because of the storm chasers not being able to do their assignments, they haven't figured out their new forms yet, I guess, but they will. Anyway, the PAs are the ones that are now becoming super aggressive. And a lot of times, they're claims that have already been paid, And I'm going to go back to these cases again for a second. The Supreme Court said, as it relates to storm chasers, there were cases where the claim had not been paid. It was post-loss, but the assignment had been made post-loss, but before payment. There was also a case, I think it was in the IMT case, where it had actually already been paid. And the storm chaser came in and said, "Hey, you should get more money. Now you've been paid, but we can get you more money." And the court didn't differentiate between the two. They didn't say if it's already been paid, it's different. They said they treated it just the same. So it's not, that doesn't seem to matter. But what we're seeing now a lot of times is, and what I'm seeing is, a lot of times the claim's already been paid. You've done your usual good work, you've got somebody on it, and amazingly fast in some cases when you have hundreds of claims sometimes out of one storm. Already paid the claim, it's all done, and then you hear from this PA, you missed it, you're way under, what are you trying to pull? And I got claims for some of you that are still out of the June 5, 2019 hailstorm. And the PAs just picked those up here in May and have started beating that drum. So, we've got claims that were paid a year ago and they're coming back. Well, the statute of limitations has run, right? Well, they're trying to get the mutuals to sign tolling agreement. You should please waive the statute of limitations because you didn't do this right. Sign here. And I hope none of you signed those because they are legal. You can do it. If you sign them and you extend the statute, they've been typically asking for 6 more months for this to sue. And that's a statute of limitations to sue you. It's 1 year for most of you in your policies. A few of you may have 2 years, but most of you have 1. And those tolling agreements work. So be careful not to just, this is just, don't worry, this is just an extension of the time to get the repairs done. I mean, that's the other thing they do is we need 180 days is up. We can't get a contractor to do the work. Would you please extend the time for us to do the work? Well, that's different. I mean, if they couldn't get a contractor to do it, and some places that's I've been told that's literally true. There was just nobody, and in a few cases, the contractors took the money and ran away. They took the money and ran off and then filed bankruptcy. So some of them, the claims were paid, but they were given to a contractor who never did anything, or who only did part of it and then ran off with the rest of the money. Okay, so so that's, be careful of what they're sending you. All right. I'm going to leave time for questions, but it's take a breath there for a second. Does anybody have any questions at this point before we go on?
Just as a quick FYI, you're all muted, but those of you that are working on computers, you can just press the space bar and you will temporarily unmute yourself. You don't have to find the button on the screen to touch or anything, so.
Anyone? Okay, I know these Zoom calls, I've been on a lot of them too. It's like, if you really want to ask a question in front of, 80 people or whatever, and maybe everybody else knows the answer, and I'm probably the only one that doesn't get it, or I didn't understand what he said or whatever. But don't feel that way. If you have that question, there's probably a bunch of other people that do too. But anyway, I'll go on because I want to cover what are we going to do about what can we do with this bullying and with these inflated claims and that. And again, I want to explain the context of this. Why are they doing this? And again, most of this is PAs, although you get storm chasers too. What they're doing is they're inflating the claims to many times what they really should be. The reason they're doing that is because a lot of them, their game plan is, you come in as a public adjuster, you say you missed a bunch of stuff, you try to bully the mutual and the insurance company end up paying you more money. You missed this, you don't know what you're doing, and they want a reinspection. Let's get out and do a reinspection because you missed it. Then they get you up on the roof and they put chalk marks all over it, the drill. Just be careful. It's not always a good idea to do the reinspection. I've got mutuals that call me, and the insured wants them to come out over and over and over again. And the problem with that is that if you go past the year and then you say, okay, sure, I'll come out again, the implication is you may want to pay them more money, or you may agree to pay them more money. Maybe we missed something. Now we've got an issue with muddying up the statute. Okay, so just be careful of that. But what they try first, that is the PAs and the storm chasers to some extent, they'll have the contractor there, bully you into paying more money. Okay, so well, that doesn't work. Then what? Well, usually they file, and what they've been doing primarily is filing, not filing, but giving you a demand for appraisal. Okay. I don't know how many of you have been through appraisals. Many of you have. I still get calls. I've never been through one of these. How does it work? And I've given other talks on appraisals. This is an appraisal under your insurance policy. If you've not had one, there's a provision in the standard policy that says if we don't agree on the amount of the claim, then you can ask for appraisal. And the provisions are a little different in each of your policies, but primarily what they say is each side picks an appraiser, and then if the appraisers can't agree, and some of them just say right up front, the appraisers pick an umpire. The two of them pick a third party who's an umpire. And then the 2 out of 3 agree on the number, that's what you get. Okay, so the game is they do a greatly inflated number. Let's take the 192,000 I mentioned before. Okay, so they have 192,000 and we paid 30. Okay, let's just say those are the numbers. Okay, a lot of these umpires, we've used ex-judges and other people who've been mediators. Well, what do mediators do? They say, we got to get everybody in the middle somewhere. And the most logical thing to do is you add up 192 and 30 and divide by 2. Okay, if you do that, it's $110,000. Okay, it's way more than what the claim is worth, way more than what it's supposed to be. Okay, so that's and there's a natural tendency, well, they can't be that far. 192, there must be way more than what the insurance company is saying. So we're gonna have to raise this up some, okay? And if the umpire and their appraiser, who's going to be one of these people they've got on retainer, if they agree, our appraiser can't stop it. Okay, so and that whole thing, that's also a mini industry throughout the country, and it's been through phases also. For a while, it was a bunch of people out of Minnesota, and you heard me in an earlier speech to this group and others say, it's a nest of vipers, I think I call them, which isn't very nice. I understand that, but they have all these appraisers who they use, and contractors and appraisers and law firms, and they had a bunch of appraisers, and then they had umpires they like to use, and sometimes the umpire would get in the car with the appraiser and come down and do 3 or 4 claims in Iowa at the same time. I mean, and even stay in the same hotel, have dinner together, all that stuff. Well, we discovered that pretty early on and said, well, we're not going to agree to those people. So then who do you get? And it's not an easy issue, because the appraiser for the PA and that group is going to try to bully the umpire. And so you have to have pretty thick skin, and you have to be able to stick to your guns. And we have some people that have been able to do that. And we also we've had experience with some umpires who are pretty good, and we'll just call it straight up. And I've had a couple new ones that I've discovered here recently that are pretty good. I mean, they understand a little bit what the game is, and they try to call it the way it should be. But that's where we're at, everybody. We're looking at PAs who are greatly inflating the numbers in anticipation of appraisal or a lawsuit. And there's a law firm that's headquartered out of Florida. They've got an office in Florida and Chicago and Miami, Chicago, Houston, Denver, LA, Minneapolis, and they have thousands and thousands of property claims all over the country. And some of these PAs are hooked up with them. So they try the bullying, and they try appraisal, or they think, not this one, we'll just sue. We'll get more money suing. So they do one or the other. Okay. Occasionally they do appraisal, and then they try to sue also. And we've had that, and we stopped it. We got the case dismissed. No, they elected appraisal, and you can't do that. You can't have another bite at the apple. So if you have been through an appraisal and then you get a threat for a lawsuit, we need to get on top of that, because we should be able to get that case dismissed. Okay. But that's the game. And appraisal it's difficult because that's not a 1-year statute of limitations. It's supposed to be with the cases say within a reasonable time after the breakdown of the negotiations. So what's a reasonable time? You can differ. It isn't reasonable to say we didn't agree and a year has passed and now we think we'll do an appraisal. I'd say that's untimely. But if it's a month or 2 or 3, given the number of claims, that's probably timely. So, and then your next question is, well, how do we get out of the appraisal? I don't want to do it. So I have people call me and say, hey, I don't want to do this. I want to opt out. How do I opt out? Well, you can't. If there's a disagreement on the number, and they say one number and they haven't signed off, and we say another number, we're going to have to do the appraisal. And then we just got to be really careful about who we pick for an appraiser and as an umpire, so that we don't get an inflated number. Okay. Okay. So I digress some on appraisal because that's where you're headed on a lot of these. What do we do in general? Well, one thing is do your usual good work. And by that, I mean, get out there, get your pictures, document what you've done and what you haven't done. And every once in a while I get one where there were so many claims. I mean, one company might have, I know some of you are going to go, oh, that's nothing. 200 claims out of one storm, Well, you're trying to be faced with 200 claims. What do? Well, you got a CAT team that comes in. So you got, adjusters from different places. You got, sometimes your reinsurer has adjusters and you can have them work it for you. You have your own adjusters. So, we've got a lot of different people working these claims, and there's a lot of them, and you think, well, we did a good job on that. And every once in a while I get one where, you know what, there were so many claims. I was trying to get on all the, we thought we paid it, but we did miss it. We did miss something. There was damage on that other side for the siding, or I guess we can't match it, or there were more shingles up than we thought, or, you couldn't really tell until it dried out a little and, the light was a little different, and, oh, geez, I see what they're talking about now. There is a problem there on that. So we need to go back and do your usual good work. But then if it turns out, when you hear from these folks that they're saying something that you didn't have in your estimate, you didn't pay it, then send it back to the adjuster that did the original and say, okay, please compare what you did with what they're saying. Okay, because sometimes something does get missed, not always, but it happens. And you don't want to have egg on your face and say later, well, we did it right, and to heck with you, you're just trying to inflate it. And then you find out we really did miss something. Now what are we going to do? We're stuck, we're sunk, because they have a point, we're going to lose on that. So send it to the adjuster that did the original and have them look at it. They don't necessarily need to go back out and look, but look at the pictures, look at their estimate, compare the estimates. And if they did miss something, fess up to it. Oh yeah, they're right on that. We owe you a little more, and then pay them what you owe them when you know what it is. And for most of you got replacement cost policies. You're going to do the ACV payment first, and then you're going to wait on the bills and make sure the work gets done, and then do the recoverable depreciation. And I get all that. And most of the time, you want to do that because you don't know, once they start doing the work, every once in a while there's, this is more complicated. There's more damage than we thought. We didn't see this, but now we ripped into it. We see there's a problem. So that occasionally happens. And if that happens, then, work with them on it. But if you did it right, you send it back to the adjuster, you did it right in the first place, stick to your guns. Because if you say, I get these adjusters call me and say, they're just driving me nuts. I've had it, I just want to be done. So they call them up and they say, all right, what's it going to take? What's it going to take to be done with this? How about if I give you 10 grand more? If I just give you 10 grand more, will you just go away? And they go, I don't know. Let me talk to the insured, they say. This is usually with a PA. Okay, guess what happens? They go, oh, good. Boy, now we got them going. I got them started, and they come back and say, really good start, 10 grand more. Now, but you owe us 50 more than that. So if you pay that, we'll be done. And then when it gets to the attorney or an appraisal, well, your guy offered your person offered 10,000 more. They must have thought they owed more money. They must have thought they missed something. Why would they offer more money if they didn't owe it? Don't they have fiduciary duty to the mutual and to the policyholders not to pay overpay claims and pay claims that aren't justified? They wouldn't do that, of course. They always follow what they're supposed to, right? So that must mean that you think you owed 10,000 more, and you didn't offer 10,000 more. So I'm gonna, that's bad faith. You knew you owed more money, and you didn't pay it. So this is a problem for you. And then, we're going to have that admission, you know, you admitted you owed more money. No, 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 that was not for a compromise and settlement, not admissible. Well, it wasn't presented in that fashion. They said, we'll pay you 10,000 more. Will you go away? That's not an offer. That's not an offer of settlement. That's just 10,000 more. So, you know, it doesn't work to say, how about if I give you a little more and will you go away? You'd think, well, surely they have no shame that, you know, they gotta, at some point, they gotta know they're being ridiculous, and they'll say, oh, all right. And then if we have, I mean, occasionally you get to the point where I'm negotiating with a PA and I say, look, we don't owe you any more money. And they say, we think you owe us 100,000 more. No, we're not going to pay you that. Well, will you pay me anything more if it goes away? And then now you're at a place where you can make sure it's done. You're not on a slippery slope. If you pay 5,000 more, will go away and you'll sign a release and a final proof. That's a different process. But just calling them up and saying, what's it going to take? And how about if I pay you 10 more? And they come back, and of course they're going to say no, but 50 grand more would do it. You know, now you've got this admission problem. Does that make sense, everybody? If you're understanding what I'm saying, please nod. So I know some of you are nodding. This is good. You're nodding. That's excellent. Okay, so stick to your guns if you did it right in the first place. Don't offer them more money because it's not going to work. They're not going to, a little more money isn't going to do it. And then document what you've done. Document what you paid. Document why you paid it. If they say there's a matching issue, document the matching, the line of sight stuff. I mean, I know you all hate this line of sight, you know, and it's case by case. And what is it? It's when I know when I see it, and you know, that whole deal we've talked about before. But you know, document why you did 2 sides, not 4. You know, that wind and hail came from the west. We have the west side a little bit on the north. We don't have the south and the east. You know, doesn't work that way. It's not all over. And so, you know, document what you did, why you did it, keep the stuff, and then see what happens. And so every once in a while they say, well, there's no easy money here. They're not given. I don't want to do an appraisal. I don't think I'm going to get much on this one because it really is a $30,000 claim. So what if I get 5 grand more by the time I pay the appraiser and the umpire? I'm not going to get any money out of this. To heck with it. On to the next one, you know. And then they just tell the insured, your insurance company's terrible. They wouldn't pay you any more money. And I'm sorry, but we're done. You know, that does happen. Okay. And then, you know, after that, have an appraisal. We do the appraisal. Be careful who we pick. Be done. If there's a lawsuit, then you call a lawyer. No, I don't guess. You need to call a lawyer because it's hard to defend those on your own. But you know, lawsuits are expensive, so they don't want to file a lawsuit every time because if there's not a lot in it, it's not worth their time. So they're a little more selective on that. Okay. All right. I think we're getting down to the end, Jenny. We got 5 minutes. Brian said leave them 15 minutes for questions, and I didn't do that because, as my wife would say, I talk on and on and on. So she's sitting here giggling at me because I do that. All right. So anybody have any questions?
Steve, the only thing I might address with you or something you want to talk about is the communication. I know a lot of public adjusters or the storm chaser come and say, no, you have to talk to me. You can't talk to the insured. You want to talk on that matter a little bit? Yep,
you bet. And it's a little bit in the outline that's mentioned, but yes, absolutely. The public well, let's start with storm chasers. Storm chasers say you can't talk to the insured. You have to talk to me. You know, don't call them, don't write them. And the new law that was just passed says specifically that nothing in this assignment can say, insurance company, you can't talk to the insured. It's specifically, that's prohibited, you know, as part of the agreement. So you can always talk to the insured. And if the storm chaser is saying you can't talk to them, don't you dare call them, That's just wrong. They can't do that. They shouldn't do that. You shouldn't do that. If you're sending emails back and forth to a contractor, make sure you copy the insured. Okay, we're just talking about storm chasers now, not PAs. It's a little different. Okay, so on the communication with the storm chaser, make sure you always copy the insured, and there's nothing wrong with you sending letters out to your insured anytime saying, this is what we've done, this is what we're willing to pay, here's the proof of loss, you know, and if the insured says put the contractor on the check, that's fine. You know, you also remember the mortgagee, if there is one, you know, and oh, don't worry about the mortgagee, I'll take care of them. Yeah, right. No, don't do that. Okay, so that's on storm chasers, and they try to bully you into don't talk to the insured. Okay, the PAs are even more aggressive in that regard. It's don't you dare call my client. You know, don't you dare talk to them. You talk to me only. I mean, I just did one that and a PA was sent me this awful letter about how my client was shoddy and terrible, and then called me every name in the book, and and I sent a letter back saying, you know, you got it wrong. Let me correct the record. And actually, we're doing another round of that here today. But in any event, the insured emails the PA and copies me and says, I haven't seen the lawyer's letter. Would you please send it to me? Making a letter from us, making an offer. He hadn't even told her yet what we would do, and he rejected it. So, so this time we're sending a copy of the letter to the insured also. But on a PA, they are allowed to negotiate with you. They are allowed to talk to you for the insured. They have a license, and their license allows them to do that. Okay, so they're allowed to do that, but they are not allowed to say you can't talk to your insured. That is not correct. Now, I had a mutual call me and say, well, how about if I just talk to the insured and I won't include the PA because they're just a pain, you know, and you know what? So no, that didn't really work either, because they do have a contract, they've got a license, they've got certain rights. So you can talk to the PA and the insured together, or if there's a meeting, have them both there, and you can write a letter to both of them. But it's really not proper to cut the PA out altogether, because now you're going around them and you're going to get an accusation that you're interfering with my contract with my client insured, and we're going to sue you for tortious interference. Okay, so don't fall into that trap. Okay, does that make sense? Does that answer the question, Brian?
Yep, thank you.
Yeah, and it's just, you know, they will tell you things that aren't necessarily true, like, you know, you're not allowed under Iowa law to talk to your insured. That's just wrong. But I do think it would be wrong, and we're kind of falling into a trap by trying to go around a public adjuster and not allowing them to be a part of a discussion that you're having with the insured, and you know, and that just isn't going to work. The insured's going to hang up and say, hey, the insurance company just called me, and the PA is going to get their lawyer to write you a letter about how they're going to sue you for tortious interference. So I wouldn't do that. Okay. All righty. Hey, we're 1 minute past, Jenny. 1:46.
Any more questions?
I got plenty of time. I'm not doing anything. Just like none of you. You got nothing to do, I know. You're just sitting there wondering what you're going to do today because you got nothing to do. All right, Brian, we should keep working on that pamphlet or handout or whatever. So, because I think it is a good idea to have something. You know, they're putting this stuff on websites and telling them how terrible insurance companies are, and here's your rights, and that, you know, we need to have something that we can give to people to say, well, let me tell you what your rights really are, you know, so that they aren't victimized.
Yep.
And I got to, just in concluding, I would say, I do feel like they're victimizing people. And a lot of times after they're all done, we get the insurance company who still has a relationship with these insureds calls and says, the insured's just sick. You know, they would have been a lot better off not ever hiring those people. They lost control of it. They feel like you know, they took X% of their claim and now they're worse off than they would have been before. And we were always ready to pay them a fair number. And they didn't know that. You know, the PA kept telling them how awful we were going to be and you can't trust them. And they're only out for themselves and they don't care about you. And that's isn't true. But that's what they're telling them. And I know you all know that, but you know, looking at these videos and that I'm seeing, it just makes me want to, you know, yell back. It's not right. But you know, we need to yell back, okay? Because we're not being presented correctly, and we need to let people know what their rights really are. So, well, thank you all very much. I appreciate it. Anytime, I'm happy to help, and I'm looking forward to getting this thing out so we can get the truth out to our folks. Okay.
Thank you very much, Steve.
Thank you, Steve.
Thank you.
Thanks,
Look
Steve.
forward to seeing everybody next week
Bye.
for our 1 o'clock session with Jack Randall on Shift Happens, or Shift Has Happened. So stay tuned.
Thanks,
All
Steve.
right. Bye.
Thank you.
I hope no more storms. Okay. All right. Bye.
Thank you.